It's me, DC, and Kat. We are have some exciting things to talk to you about today. I'm an MLM dropout. I was in 2 MLMs, and I just got out of my very last MLM, April 24th of this year. It was Young Living, which is so appropriate because we're about to have some tea time with these transcripts that Mombi sent me, and it's been a whole moment. We have some technical difficulties on my channel. I think everyone's used to it, but if you're new, I'm doing my best. I literally am trying so hard. As Elaine Brederoff said, I'm trying, Your Honor. I'm trying. So I'm going to let Kat introduce herself to my channel. I'm so excited that she is live streaming with me, and I think hopefully she will say yes to coming on more, because this is going to be a series because it's so long. There's 4,000 pages of transcript. And just to give you a little bit of a teaser, a spark notes, some of the transcripts involve talking about performing surgery without a medical license. So it's going to be a good time. I'm going to hand the microphone over to Kat and let her introduce herself, and please give her a very warm welcome.
Thank you for letting me come on. I did one live stream on my channel and I had a blast. I have a little one whose schedule kind of makes it challenging for me to know when I can do live streams and stuff, but I didn't realize how much I liked live streams until he came here. So yeah, I'm Kat. I'm a licensed registered dietitian nutritionist, and I was in an MLM. I was in Juice Plus, and actually my live stream that I did do, I spoke a little bit about my experience, my history with that. A lot of the guilt and shame that I felt moving through that and having that as part of my experience being a health professional, a nutrition professional, and being part of a nutrition related MLM. It's something that I think is important to talk about, though. There are actually a lot of, one of the main reasons why I joined that MLM was because there were so many other dietitians, there were registered nurses, pharmacists, medical doctors, so many health professionals in there. And so it's really important to talk about it. I tried Young Living through a friend. I ordered I wanted to help her out. I'm a military spouse and she was a military spouse, and she was a distributor. I thought that I was just ordering like a kit, just like a starter kit, as far as like starter of like starting essential oils, like using them, like smelling them. I knew that they weren't going to really like change my health or anything. I just wanted them to smell good. And then I wanted to support her. Yeah. And then months after I purchased that starter kit, I realized that I was actually a distributor. And so I was kind of upset about that because she did not tell me that I was joining in that way. I just wanted to buy it and be done with it. So that's my experience with Young Living, other than creating a couple videos here and there and sprinkling them in.
Awesome. Well, that is interesting to hear. Not necessarily surprised that you were signed up as a brand partner without your knowledge, because they do play it off that you're going to get this great deal. You're going to get a great discount, and it's hit or miss whether you find out that you're a brand partner or not, because to get that discount, you got to be, or at least you used to have to be a brand partner, and they get $50. They used to get $50 a person to sign them up for that premium starter.
So she made money off me.
Yeah, she did.
Like beyond just the order.
Yes. Love that. Kat is a registered dietitian. I don't know. I talk about Beachbody a lot, and they're wild over there with the nutrition advice. And we're just like, please talk to a professional. Please talk to someone like Kat. Please stop it. Just stop it.
It's so frustrating.
So, yeah. And Young Living does the same thing. They have a lot of health claims. They prescribe all the time. They prescribe, eat this to feel better. And it's wild. So today we are going to look at the first transcript file. It's not Young Living versus Young Living. I made that as a joke because when we're going to be reading these transcripts, it really pulls the rug out from under Young Living. The title of the lawsuit was Young Living versus doTERRA. That's the foundation. Like, that's the reason they came together in court and why we have these beautiful transcripts for the rest of time. So
thank you, Mombi.
Yes, Mombi is, if you all understood how much info Mombi has and that she doesn't necessarily always like give out because she's just trying to take down MLMs behind the scenes, kind of without that credit. She gave me an incredible video from that someone had leaked to her from a call. And she was like, we can do this unlisted. Then her informant saw it and said, let's go public. Mombi is the one that gave me that. And she was in the live chat. We were all like, bless you, Mombi. Thank you so much. and she gave us these transcripts too. Before we start, I'm going to tell everyone we're live on Instagram, and
I will share too.
Tanya, Mermeow, Janet, Sky, Deanna, Jessica. What up, everybody? Lynn is going to take a nap. We've got Janet, Jessica. Y'all, thank you so much for hanging out with us. We're going to try to make this spicy and not as dry, but it's pretty interesting right from the get-go because a juror is late and they got in trouble with the judge.
Elizabeth, how long were you in Young Living?
Yes, tell us all the details, Elizabeth. Let me turn the music back up a little bit. All right, I'm here. I think my kitten nail file and trimmers just came. Oh, Janet just got 2 new kitties. They're so cute and they're little ferocious and sassy. 3 years. I was in for 3 years too, Elizabeth. I'm going to go ahead and share my screen and I'm going to try to get my trial pad to work. You're never going to want to stream with me again. I promise it's normally not this bad.
No, I'm good.
Oh, God. Live chat, you're the best. Sorry, thanks for being patient.
Thank you.
Oh, man. It's like Young Living is like the karma that I have brought upon myself. Oh, here we go. Your desktop? Yes, thank God. We're back. Okay, there we go.
Whoa.
Yeah, is that better? So the court, if y'all listen to Emily D. Baker, the court means that's the judge who's talking. She's about to ream a juror. Again, these are all public documents, so it is going to have the juror's name written down, but I'm not going to read it because I was trying to redact it and I got thwarted. Okay, we're back on track. So the court said, thank you. You may be seated. We're back on the record on the Young Living versus doTERRA. And I have a juror who did not appear this morning, who I'm advised has now appeared. Juror number 52. Come up to the podium, please. You were directed to appear here at 8:30. Why weren't you here?
I was out of town for the weekend and I just read it at 1:30 that I was supposed to be here at 8:30. So I came as soon as I read it.
The court said these notices went out some time ago.
The juror said, I got mine on Thursday, got the envelope on Thursday. I have the date marked on the 16th, marked the 16th, and then I opened it on Thursday and then went out of town for the weekend and then I opened it today.
The court, well, you'll be well advised to check your mail more frequently than that. I'll vacate the previous order. It was an order to show cause and potentially a warrant for your arrest. I'll vacate that order since you appeared here today. Thank you. You're excused. Do we need anything else before we bring in the jury? Holy crap.
Right.
She was
That's
mad.
to start off with.
Yeah. Yep.
Mr. Toth, no, Your Honor.
No questions. All right. We'll go ahead and get them. Thank you.
Mr. Gaylord, Your Honor, my apologies. We're redacting all names, right?
Mr. Hawkins is a lawyer, so we can say his name.
Okay.
Yep.
Mr. Hawkins is reminding me of one issue. If you're going to read it gets cut off. The bailiff said, all rise for the jury.
The court says, could you hold on just one moment?
Back to Mr. Gaylord. My sincere apologies. Mr. Hawkins raised an issue that we did not mean to raise with you. If you're going to read the stipulated facts as part of the preliminary instructions, we raised and filed an objection on that point in which we asked the court not to read 4 of those paragraphs on the grounds that we have filed a motion to reconsider, and 2, objected to those because they're now asking them to say we entered into those arguments. As the court knows, last Tuesday, we were before the court arguing that the agreement has been superseded, and we are raising the objections, A, to preserve our objection, and B, to assure that the court understands our position, which is those agreements have been superseded, and therefore the court should not read those. We know the plaintiffs are going to say, well, it's already been stipulated to. We're simply putting the court on notice of our objection. We can raise that issue. The court may address that. In addition, we have our motion to reconsider, which addresses other issues, but they're more evidentiary.
I had intended to address those once we finish with the preliminary instructions and send the jury on their way. I thought we could discuss that.
Mr. Gaylord, my only concern we have is, if I can make this point, our client doesn't dispute that he entered into the agreement. We don't dispute that they entered the agreement. Interesting. Okay. I
Yeah.
think two issues become what the lockout period is but our point is that we want to preserve that we entered into an agreement, but that's preserving our right to argue with you later that we think it's superseded, so it doesn't exist. That's why we're raising it one. If the court is going to read it, I suppose it is. The other option the court has is just to not read it into the record, those 4 paragraphs.
Okay, the court said thank you. Do you want me to read Mr. Smith or do you want
Yeah,
to
I
read?
wonder what those 4
Yeah.
paragraphs are.
Yeah. Mr. Smith, sorry, Your Honor. A moment ago, you called the case Young Living v. doTERRA, I think. Are we going to change the name of the case to Young Living versus Sterling? That was the name sent out on the jury questionnaire. Since doTERRA is no longer around? Oh, did they get removed from this lawsuit? Since doTERRA is no longer around, are we going to change the name? I'd rather not have doTERRA as a named defendant anymore to the jury, but it's up to you, Your Honor. Myself, the court. I don't really have a problem with it either way. I think it still shows up when I punch it in my computer. I think it still shows up as Young Living v. doTERRA. That's why I was still saying it that way. Oh, sassy. Ooh, okay. I understand, of course, the procedural things that have happened. If you want me to say Young Living v. Sterling, I don't think it matters one way or the other, but I do have it printed up that way on the preliminary jury instructions that we have ready to pass out to the jury.
Mr. Toth, do you want me to address your or Mr. Gaylord's comment? We're here to address that. We filed oppositions to all these motions.
The court, I did see that opposition. I'll have Mr. Gaylord's objection be noted on the record.
Thank you, Your Honor.
The court said, all right, will you tell her we're ready now?
My apologies, Your Honor.
No, you're fine. The jury entered the courtroom. The court said, thank you. You may be seated. I'll note for the record, the jury is present and we have handed out, I believe, the preliminary jury instructions. Yes, we'll do that right now. Members of the jury, we are about to begin the trial of a civil case. I would like to describe how the trial will be conducted and explain what we will be doing. To that end, I've provided preliminary jury instructions numbered 1 through 25. I will supplement these instructions later in the trial. All the instructions taken together govern your conduct and deliberations during the trial, and it must be carefully followed. As I read these instructions to you, please follow along on your copy. The order in which they are given has no significance or importance. Although there are many instructions, all are equally important. Don't pick out one and ignore the rest. If I repeat or state an instruction in varying ways, no emphasis is intended. Finally, the headings are for your convenience only and are not to be considered in interpreting the instructions. Number 1, now that you have been chosen as jurors, you are required to decide this case based only on the evidence that you see and hear in this courtroom and the law that I will instruct you about. For your verdict to be fair, you must not be exposed to any other information about the case. This is very important, and so I need to give you some very detailed explanations about what you should do and not do during your time as jurors. First, you must not try to get information from any source other than what you see and hear in this courtroom. It's natural to want to investigate a case, but you may not use any printed or electronic sources to get information about this case or the issues involved. This includes the internet, reference books or dictionaries, newspapers, magazines, television, radio, computers, Blackberries, iPhones, smartphones, PDAs, or other social media or electronic device. You may not do any personal investigation. This includes visiting any of the places involved in this case using internet maps or Google Earth, talking to possible witnesses, or creating your own experiments or reenactments.
That's hard.
Yeah, way hard, brutal.
Because I feel like you're not getting the whole story, but I understand. I mean, that's normal.
Yeah.
But
Yep. And I think so. I don't know if you followed the Johnny Depp Amber Heard case. I only asked that because there's some lawyers on YouTube who did, and they were really adamant about not trying to look up other information about the case. Like they just wanted to watch the trial and see where their conclusions led them to based on what they saw. It's a big thing, at least in the court of law, but it's hard to do, especially with how easily accessible the internet is. It's almost impossible. But the few lawyers I've talked to, my husband's a lawyer, they've all said that when you do give the jury instructions to the jury, that they take it pretty seriously. So while it's not a perfect instruction, a lot of them are like very dedicated to following that instruction from the court.
Makes sense.
You
My
may
sleuthing self, though.
Yes. You may notify your family and your employer that you have been selected as a juror, and you may let them know your schedule, but do not talk with anyone about the case, including your family and employer. You must not even talk with your fellow jurors about the case until I send you to deliberate. If you are asked or approached in any way about your jury service or anything about this case, you must respond that you have been ordered not to discuss the matter, and then please report the contact to the clerk or the bailiff, and they will notify me. Also, do not talk with the lawyers, parties, or witnesses about anything, not even to pass the time of day. I know that these restrictions affect activities that you consider to be normal and harmless and very important to your daily lives. However, these restrictions ensure that the parties have a fair trial based only on the evidence and not on outside information. Information from an outside source might be inaccurate or incomplete, or it might simply not apply to this case, and parties would not have a chance to explain or contradict that information because they wouldn't know about it. That's why it's so important that you base your verdict only on information you receive in this courtroom. Courts use to sequester or isolate jurors to keep them away from the information that might affect the fairness of the trial, but we seldom do that anymore. This means we must rely upon your honor to obey these instructions, especially during recesses when no one is watching. Any juror who violates these restrictions jeopardizes the fairness of the proceedings, and the entire trial may need to start over. That is a tremendous expense and inconvenience to the parties, the court, and the taxpayers. Violations may also result in substantial penalties for the juror. If any of you have any difficulty whatsoever in following these instructions, please let me know now. If any of you becomes aware that one of your fellow jurors has done something that violates these instructions, you are obligated to report that as well. If anyone tries to contact you about the case, either directly or indirectly, or send you any information about the case, please report this promptly as well. Notify the bailiff or clerk, who will notify me. These restrictions must remain in effect throughout this trial. Once the trial is over, you may resume your normal activities. At that point, you will be free to read or research anything you wish. You will be able to speak or choose not to speak about the trial to anyone you wish. You may write or post or tweet about the case if you choose to do so. The only limitation is that you must wait until after the verdict when you have been discharged from your jury service. So keep an open mind throughout the trial. The evidence that will form the basis of your verdict can be presented only one piece at a time. It is only fair that you do not form an opinion until I send you to deliberate. Instruction. That was only instruction number 1? Oh my God. Oh,
how are we going to do this?
Also, after this, how devastated would you be if you're not juror on the Alex Jones trial? Yep. Instruction number 2, you and I and the lawyers play important but different roles in the trial. I supervise the trial and decide all legal questions, such as deciding objections to evidence and deciding the meaning of the law. I will also explain the meaning of the law. You must follow that law and decide what the facts are. The facts generally relate to who, what, when, where, how, why, or how much. The facts must be submitted by the evidence. The lawyers present the evidence and try to persuade you to decide the case in favor of his or her client. Television and the movies may not accurately reflect the way real trials should be conducted. Real trials should be conducted with professionalism, courtesy, and civility. Number 3, the party who brings a lawsuit is called a plaintiff. In this case, the plaintiff is Young Living Essential Oils, LC. I will sometimes refer to the plaintiff as Young Living. The parties against whom the lawsuit is brought are called the defendants. In this case, the defendants are all of these people. And I'm not, so JH, LS, DS, and EW. And again, I think they're public. I think that's fine because this is on Pacer, so it's not the end of the world that they're not redacted. But Young Living seeks damages for alleged breach of contract. The defendants deny liability. Okay, that's simple enough. I mean, it's complicated, but it's simple enough. So Young Living said, hey, y'all breached our contract. We want money. And the defendants say, we didn't breach your contract. We're not giving you any money. Number 4, the trial will proceed as follows. The lawyers will make opening statements outlining what the case is about and what they think the evidence will show. Plaintiffs will offer evidence first, followed by defendants. I may allow the parties to later offer more evidence. Throughout the trial and after the evidence has been fully presented, I will instruct you on the law. You must follow the law as I explain it to you, even if you do not agree with it. The lawyers will then summarize and argue the case. They will share with you their views of the evidence, how it relates to the law, and how they think you should decide the case. The final step is for you to go to the jury room and discuss the evidence and the instructions among yourselves until you reach a verdict. Number 5, the order in which I give the instructions has no significance. You must consider the instructions in their entirety, giving them all equal weight. I do not intend to emphasize any particular instruction, and neither should you. Number 6, you must decide this case based upon the facts and the law without regard to sympathy, passion, or prejudice. You must not decide for or against anyone because you feel sorry for or angry at anyone.
See, I would lose it there.
Me too. I love my feelings. I mean, I do. I can't help it.
Right. I mean, I think as YouTube content creators, I think that kind of aligns well.
And it's hard because we've seen so many people harmed by these multi-level marketing companies. We see the deceptive recruiting practices. We see the information control. We see the behavior control. And we see people who've lost a lot of money. And so we come into this with, I've got big feelings about Young Living. I have big feelings about them saying our past, our history is incredible and we've done incredible things. Being involved in the death of a child, that is not incredible. And to gaslight people who bring up questions about that seems, you missed the mark there, Young Living. You missed the mark in a big way. And so again, reading this, it's, I definitely would be yeeted from this jury for sure if I would have been picked for it. And it's a tough job. It for sure is a super tough job. I could never be a juror. Is that a fly on the ceiling? I'm sure it's a fly. Yeah. Oh my gosh, Dave.
Yeah, I'm really excited to get to what I don't know, excitement is the right word, but what they are saying how they breached the contract.
Yes, I'm very excited too. Yeah, I'm excited to see what they say. At the end of the trial, you must make your decision based on what you recall of the testimony. You will not have a transcript or recording of the witness's testimony. I urge you to pay close attention to the testimony as it is given. Number 8, you may take notes during the trial and have those notes with you when you discuss the case. If you take notes, do not overdo it and do not let your note taking distract you from following the evidence. Your notes are not evidence, and you should use them only as a tool to aid your personal memory. I will secure your notes in the jury room during breaks and have them destroyed at the end of the trial. And number 9, person means any individual, corporation, organization, or other legal entity. Number 10, the fact that one party is a natural person and another party is a corporation or other legal entity should not play any part in your deliberations. You must decide this case as if it were between individuals. Number 11, there are multiple parties in this case. Each party is entitled to have its claims or defenses considered on their own merits. You must evaluate the evidence fairly and separately as to each plaintiff and each defendant. Unless otherwise instructed, all instructions apply to all parties. Although there are 4 defendants, that does not mean they are equally liable or that any of them are liable. Although there are 4 defendants, that does not mean they are all equally liable or that any of them is liable. Each defendant is entitled to a fair consideration of his or her defense against each of Young Living's claims. If you do not include that one defendant is liable, that does not necessarily mean that one or more of the other defendants is liable. Number 12, you may have heard that in a criminal case, proof must be beyond a reasonable doubt, but this is not a criminal case. In a civil case, such as this one, a different level of proof applies, proof by a preponderance of the evidence. When I tell you that a party has a burden of proof or that a party must prove something by a preponderance of the evidence, I mean that the party must persuade you by the evidence that the fact is more likely to be true than not true. Another way of saying this is proof by the greater weight of the evidence, however slight. Weighing the evidence does not mean counting the number of witnesses nor the amount of testimony. Rather, it means evaluating the persuasive character of the evidence. In weighing the evidence, you should consider all of the evidence that applies to a fact, no matter which party presented it. The weight to be given to each piece of evidence is for you to decide. After weighing all of the evidence, if you decide that the fact is more likely true than not, then you must find that fact has been proved. On the other hand, if you decide that the evidence regarding a fact is evenly balanced, then you must find that the fact has not been proved and the party has, therefore, failed to meet its burden of proof to establish that fact. At the close of the trial, I will instruct you in more detail about the specific elements that must be proved. Number 13, evidence is anything that tends to prove or disprove a disputed fact. It can be the testimony of a witness or documents or objects or photographs or certain qualified opinions or any combination of these things. You must entirely disregard any evidence for which I sustain an objection and any evidence that I order to be struck. Anything you may have seen or heard outside the courtroom is not evidence, and you must entirely disregard it. The lawyers might stipulate or agree to a fact, or I might take judicial notice of that fact. Otherwise, what I say and what the lawyers say usually are not evidence. You are to consider only the evidence in this case, but you are not expected to abandon your common sense. Oh, that's nice. Okay. You're permitted to interpret the evidence in light of your experience. Oh. Number 14, a fact may be proved by direct or circumstantial evidence. Circumstantial evidence consists of facts that allow someone to reasonably infer the truth of the facts to be proved. For example, if the fact to be proved is whether Johnny ate the cherry pie and a witness testifies that she saw Johnny take a bite of the cherry pie, that is direct evidence of the fact. If the witness testifies that she saw Johnny with cherries smeared on his face and an empty pie plate in his hands, that is circumstantial evidence of the fact. Number 15, testimony in this case will be given under oath. You must evaluate the believability of the testimony. You may believe all or any part of the testimony of a witness. You may also believe one witness against many witnesses or many against one in accordance with your honest convictions. In evaluating the testimony of a witness, you may want to consider the following. 1, personal interest. Do you believe the accuracy of the testimony was effective one way or the other by any personal interest the witness has in this case? 2, bias. Do you believe the accuracy of the testimony was affected by any bias or prejudice? 3, demeanor. Is there anything about the witness's appearance, conduct, or actions that causes you to give more or less weight to the testimony? 4, consistency. How does the testimony tend to support or not support other believable evidence that is offered in this case? 5, knowledge. Did the witnesses have a good opportunity to know what he or she is testifying about? 6, memory. Does the witness's memory appear to be reliable? 7, reasonableness. Is the testimony of the witness reasonable in light of human experience? These considerations are not intended to limit how you evaluate testimony. You are the ultimate judges of how to evaluate believability. Number 16, you may believe that a witness on another occasion made a statement inconsistent with that witness's testimony given here. That doesn't mean you're required to disregard the testimony. It is for you to decide whether to believe the witness. Holy crap, how many numbers are there? Holy crap. Hello, Lori. Everyone who's come in the chat. I'm trying to read and not Mombi, what's up? Everyone, the reason we have these transcripts is because of Mombi. She has graciously allowed us to create the longest reading of a lifetime here on YouTube. And look at Young Living versus doTERRA. If you saw the title, you saw I said Young Living v. Young Living because it's a joke. Because the stuff that is in these transcripts just pulls the rug out from under Young Living, in my opinion. And we're not lawyers, we're just readers, and we've had bad experiences in multi-level marketing. And Kat and I have both been in Young Living. So
surprisingly, unknowingly,
it's a surprise. So it's going to be a good time, but just want to make that clear. We're just readers, and Kat's actually a registered dietitian, so she's the expert on our panel. I'm just here.
Nothing with law. I have zero law education experience. Never even been called to jury duty. Actually, I was called in jury duty, but I was a full-time student.
Oh, wow.
Time.
Yeah.
Now that I say that, I'm probably going to get it in the mail.
Knock on wood. Don't send bad karma to Kat. Okay. Number 17, if you believe any witness has intentionally testified falsely about any important matter, you may disregard the entire testimony of that witness, or you may disregard only the intentionally false testimony. Number 18, a stipulation is an agreement. Unless I instruct you otherwise, when the lawyers on both sides stipulate or agree to a fact, you must accept the stipulation as evidence and regard that fact as proved. The parties have stipulated to the following facts. Defendant H, I'm going to have to say their names because they're going to keep repeating them. Defendant Harrison entered a contract with Young Living dated February 1, 2001. Okay. Defendant Harrison's last day of employment at Young Living was February 11, 2008. Oh, he jumped ship. Okay, got it. Defendant Harrison's lockout period ended February 11th, 2009. Defendant Shepard entered into a contract with Young Living dated February 25th, 2002. Defendant Shepard's last day of employment at Young Living was February 22nd, 2008. Defendant Shepard's lockout period ended February 22nd, 2009. Defendant Sterling entered a contract with Young Living effective April 1st, 2004. Okay. Defendant Wright entered a okay, is this is page 20. Okay, I thought we'd missed something because they didn't talk about the lockout
When did
period.
Sterling leave?
Yeah. Defendant Wright entered a contract with Young Living effective April 1st, 2004. Defendant Wright's last day of employment at Young Living was October 1st, 2007. Defendant Wright's lockout period ended April 1st, 2008. At all relevant times, Young Living distributors were independent sales contractors. Oh, okay. Independent sales contractors who can cancel their distributor agreements with Young Living at any time for any reason upon providing written notice to Young Living. Since the parties have agreed on these facts, you must accept them as true for purposes of this case. Number 19, a deposition is the sworn testimony of a witness that was given previously outside of court with the lawyer for each party present and entitled to ask questions. Testimony provided in a deposition is evidence and may be read to you in court or may be seen on a video monitor. You should consider deposition testimony the same way that you would consider testimony of a witness testifying. Number 20. Some evidence is received for a limited purpose only. When I instruct you that an item of evidence has been received for limited purpose, you must consider it only for that limited purpose. Number 21. From time to time during the trial, I may have to make rulings or objections on motions made by the lawyers. Lawyers on each side of the case have a right to object when the other side offers evidence that the lawyer believes is not admissible. You should not think less of a lawyer or a party because the lawyer makes objections. You should not conclude from any ruling or comment that I make that I have any opinion about the merits of the case or that I favor one side or the other. If a lawyer objects and I sustain the objection, you should disregard the question in any answer. During the trial, I may have to confer with the lawyers out of your hearing about questions of law or procedure. Sometimes you may be excused from the courtroom for that same reason. I will try to limit these interruptions as much as possible, but you should remember the importance of the matter you are here to decide. Please be patient, even though the case may seem to go slowly. Number 22. Under limited circumstances, I will allow witness to express an opinion. Consider opinion testimony as you would any other evidence, and give it the weight you think it deserves. You may choose to rely on the opinion, but you are not required to do so. If you find that a witness in forming an opinion has relied on a fact that has not been proved or has been disproved, you may consider that in determining the value of the witness's opinion. Number 23, in resolving any conflict that may exist in the testimony of expert witnesses, you may compare and weigh the opinion of one against that of another. In doing this, you may consider the qualifications and credibility of each, as well as the reasons for each opinion and the facts on which the opinions are based. You may not discount the opinions of an expert merely because of where he or she lives or practices. Number 25. Charts and summaries that are received as evidence will be with you in the jury room when you deliberate, and you should consider the information contained in them as you would any other evidence. Other charts and summaries will be shown to you to help explain the evidence. However, these charts and summaries are not themselves evidence, and you will not have them in the jury room when you deliberate. You may consider them to the extent that they correctly reflect the evidence. Now, normally at this point, what we would do is begin with opening statements. It's nearly 4 o'clock and probably too late to start. We wouldn't be able to find a very good breaking off point, I think, if we start with opening statements at this point in the afternoon. What I'm going to do is release the jury for today and have you return tomorrow morning. One will begin with opening statements and presentation of evidence. I'll have you meet with Cassie downstairs at 8:30. You can confirm with her exactly where she wants to meet with you, and then we'll bring you up and get started shortly thereafter. Again, I'll admonish you not to discuss the case with one another or anyone during the pendency until it's time to deliberate. All right, we'll release you for the afternoon. See you in the morning. The jury left the courtroom. The court, thank you. You may be seated. All right, we have some housekeeping matters, I think, in the form of motion to reconsider and an objection, which I did have a chance to read through over the weekend. let's see. Mr. Gaylord, you filed the motion to reconsider. We can start there if you'd like. I think I muted you. Hold on.
No, I muted myself.
Okay.
I heard a little one.
You're good. You're good.
All right, Mr. Gaylord comes in now. Your Honor, I don't want to waste the court's time with this issue. We filed the motion in part to preserve our record, but there's a piece of it that I think the court made its ruling, and I guess we need some clarification on that. The way we view the ruling was that you were precluding us from having Mr. Shepard, Ms. Shepard, or Mr. Harrison testify about those documents. Okay. But as we read the rules and as we went back and looked at it on a couple of fronts, we looked at, first of all, our disclosures. We believe the disclosures were adequate and complete as it relates to the issues here. And there was no obligation to supplement. The evidence is that the depositions were taken before the documents were produced. There was no obligation to supplement and give you new legal theories because that's really what they're talking about. We have a new legal theory and you can't wait until the eve of the trial. We didn't wait until the eve of the trial. We simply informed the court and it was an evidentiary issue. Okay. Second of all, setting that aside, we still have the right to impeach witness with that evidence. And if they want to continue to advance the notion that this document is controlling, we have the right to at least present that document to a witness. If they want to deny that, in fact, Mr. Harrison and Ms. Shepard enter into subsequent employment agreements with a resource management company. And if they chose to acknowledge that they did, I'm done. If they don't, I get to impeach them with it. There's nothing in the Rule 26 that prohibits me or requires me to have even disclosed this fact to the court. I could have waited until taking on Mr. Young or the 30B6 witness or whomever and presented them with the evidence. They would have either accepted it or denied it, and I would have to be free to present that document. I have no obligation to disclose to the other side my legal theories and or to disclose impeachment testimony. On that ground, we are just looking for clarification that I can at least present those documents and or questions the witness on what is aromatic and whether those agreements were entered into by Mr. Harrison and Ms. Shepard.
Thank you, counsel. Okay. You want to be Mr. Toth?
I can be Mr. Toth.
Okay. All right.
All right, Mr. Toth. Well, Your Honor, we're back here. This is the next day.
No, this is the same day. It's he's throwing shade already because he's just throwing shade because he's like, we're talking about this again. We had the same conversation, so go ahead.
I was like, is this another? No, he's just shading.
No, he's throwing shade. It's like as per my last email, that's the same kind of tone that he's having here.
Per my last email in person. Well, Your Honor, we're back here having the same argument we had last Tuesday, and it's improper for all the same reasons as it was improper last Tuesday. You'll notice in conjunction with the motion to reconsider that what they also filed. They also filed an attempt to walk back their objections, their own stipulated jury instructions, and the evidence, the documents that they themselves stipulated as being admissible. In other words, they're again trying to change the evidentiary playing field. So they want to characterize it as, this is just a different legal theory, but it's not. What they're doing is they're saying, we don't want to have those facts count against us anymore. We don't want to have there be a lockout period. We don't want to be able to argue against that. Interesting. Okay, so now we're going to add to the jury's confusion because now there's stipulation, which the court has properly held their feet to the fire following the Utah Supreme Court precedent. It's clear as day, you can't walk that stipulation back at this point of the trial. The jury has now been charged. Now they want to try and create this incredible confusion for the jury using documents and agreements that initially they didn't agree to produce. They didn't agree. Then they sought Young Living's approval to be able to bring them to trial. They're not relevant, Your Honor. They're not relevant because they've already stipulated to that these individual defendants entered into those agreements that they're enforceable. And that's fundamentally unfair to Young Living.
Oh, womp womp. Okay.
How? How is it unfair? Yeah. As the court pointed out last Tuesday, it's an entirely different evidentiary record. If what they want to do is make aromatic research management companies' corporate status and structure and the nature nature of that co-employment relationship. And they want to try to blur that line and say, oh, that company is the same as this company. This is an entirely different evidentiary question. We don't have that evidence to put on because no one's ever raised that before. No one's brought that to anyone's attention. It's never been disclosed as a theory. It's clear that they never thought it was a theory, Your Honor. They never thought this was their theory of the case until 2 weeks ago. So are those defendants, the 4 distributors, with doTERRA?
Yep. So from what I understand,
All of
there
them.
was part of the C-suite at Young Living left to create doTERRA, and Young Living is going after these, I guess, bigger sellers that were with Young Living before. So I don't remember. I mean, I don't know their names off the top of their head. I don't know if Mombi has other information on that. They're upset about something having to do with their contract,
which I'm excited to get to that part.
Yes, me too. Yeah, and this is a little bit of we realize it's tedious reading this stuff. It's important, I think, to lay the foundation that the jury has a lot of conditions on what they can and cannot decide upon and how they're supposed to decide based on the instructions given by the court. As we read through this, there's going to be some juicy depositions we're going to read, so it's going to be worth the wait, but this is all foundational. I think it's important. Thanks for bearing with us, and we will never have technical difficulties after this after this point in time.
We know what to do now.
Yes, we know what to do now. I just have to freaking get my iPad to work next time. So because I had the different things highlighted. So it's womp womp. Okay.
Yeah, the parts that we really wanted to read out.
Yep.
Did you just do the first PDF? There's several ones.
PDF today. So we're gonna do there's 4,000 pages worth of transcripts, and this is just the first PDF today. So I thought we could start with it.
6,
Yeah.
7, 8. Yeah, there's a lot of them.
Yeah, there's a lot. And this one's 99 pages.
Yeah.
We're on page 29 right now. So
all right.
Yeah, it's gonna be a good time.
As you notice the dichotomy in their argument, on one hand, they say, Your Honor, we disclosed, that we might have defenses, boilerplate defenses in our answer. That was enough to put Young Living on notice. And then they themselves say, as they come into court literally a week beforehand and say, we just figured this out. We really apologize to the court, but we have to be able to present this theory. What does that tell you? Well, it tells you that they didn't know. They've never brought this. They've never been advanced. It's never been advanced as a theory. Let me give you an example. Mr. Harrison did initially dispute that he had entered into that agreement. What he said was that that's not my signature. And we had to go to the time and expense. So they had to go to the time and expense. And you can see the expert reports, you can see the testimony on it, the disclosures that were made. That was Mr. Harrison's defense. That's not my signature. We had an expert look at it. Expert opines that's definitely his signature. And on the eve of the trial, they walk back that defense and say, no, we're not going to contest that. He entered into the agreement. We have a stipulation. And then literally a month and a half after those arguments were made, less than a week before trial, they walk back and say, no, we want to change that theory again. And now we want to talk about this aromatic resource management contract because you've got a new idea how we can escape this case.
Ooh, ouch.
Yeah.
Like nasty. I was like, okay, come on strong, dude. All right.
Right. That's fundamentally unfair. That changes this case. The parties have agreed to try. They're trying to walk back their stipulations. That's why when they asked for reconsideration, what's filed simultaneously with those are attempts to change the evidentiary playing field. That's not fair to Young Living. They've had the ability to ask about all those contracts. They've had those contracts for years and they've never done anything with them. And in fact, they did ask Gary Young about the Aromatic Research Management Company in his second deposition. They asked about that contract. They just didn't pursue this theory with it. That wasn't the theory they articulated. If you look at the first 15 pages of Gary Young's second deposition, they ask a ton of questions about Aromatic Research Management Company. That's not something they've ever pursued. In the same concerns that the court had when being backed into a corner, trying to make a decision about is Aromatic Research Management Company the same company or is it a different company? What is its structure? When was it formed? This theory only holds together if Young Living Essential Oils LC and Aromatic Research Management Company are one and the same. Otherwise, their entire theory falls away as a house of cards. They can't show that factually. There's no evidence for that factually. Now it's going on. Now what's going to get put in front of the jury on top of what the stipulated jury instructions are is rank speculation about meaning the terms and meaning of contracts. That's not appropriate. And it's what it will do, Your Honor, is confuse a jury and lead to, frankly, a lot of irrelevant testimony being placed in front of the jury. I wonder what the irrelevant testimony that they're concerned about is.
Yeah, I'm sure this is like all them just trying to get, they're just trying to make something stick for, they're upset about something and they're just trying to say like, hey, it's irrelevant, it doesn't count. And then the judge is going to be like, I don't know. If you're just joining us, this is Young Living v. doTERRA, which is actually Young Living v. former independent contractors from Young Living. Yes, Young Living. And it's wild. And the reason I did Young Living v. Young Living in the title is because the transcripts we're about to read throughout this series that we're going to be doing on YouTube, they literally, there's so much about Young Living in them that just really kind of pulls the rug out from under Young Living itself. So even though we're focusing on this litigation, these transcripts, it really is to highlight and pull the curtain back on Young Living. And all of these are our opinions. We're just reading the transcripts. These are publicly available. I'm going to try to not have technical difficulties and successfully redact some information, but on Pacer, normally things are redacted correctly. So we're just trying to be extra careful and extra nice to people who don't want to have their names blasted on the internet. Kat is a registered dietitian, and she was also surprisingly a brand partner in Young Living. I didn't know that. She didn't know that because when she signed up to help her friend and she got a discount, she didn't realize that they put her as a independent contractor. It wasn't a good time. And I think it was a surprise. Kat talked a little bit about that in the intro. Then we had about 30 minutes of technical difficulties. So what I'm going to do is when we finish streaming this, I'm going to turn it private. I'm going to download it. We're going to cut it up so that it's as short as possible for the viewers, to be respectful of your time. If you didn't catch us on the live stream, replay crew, much love to you. We're going to try to be as professional as possible, but y'all know how it is on my channel. Sometimes happen. So, and I'm also going to send this video to Kat. And so next time Kat and I stream, we will be streaming to her channel too. That was a ball dropped on my end, but this video will also be on Kat's channel, and we want to be able to spread the love, spread the message about Young Living and stuff that's happened. And so we're not gatekeeping this information. And all of these transcripts were provided by Mombi, who is an incredible researcher, writer, activist, advocate for change and taking down unethical businesses in the MLM world, and a lot of them are.
That was a good summary.
We realized, I think both Kat and I realized that reading the foundational parts of this are a little bit dry. It's a little bit, maybe not super interesting, but it's important. Understanding the restrictions that the jurors are under, understanding how they are supposed to make the decisions. One, it's educational because you're hearing it from the judge. I think it helps in other situations about giving us more info, more empathy, more knowledge about how hard it is to be a juror too. It's a little bit different, obviously, in a court of law. So we can make quick snap judgments when we're just quick reacting to something, but they can't in this situation. We just got through 20 pages of the judge saying, you can do this, you cannot do this, you can decide this, you cannot decide this. You know, so
and this is also 2017, so before a lot of more well-known anti-MLM content was around.
Yep, exactly. So Kat and I are taking turns reading. Kat is reading, I think this is Mr. Toth.
I believe it was where it was, it's extremely prejudicial to Young Living. We could put witnesses on. Presumably we can go out and find them. There's a whole different set of documents that need to be produced and reviewed that relate to the corporate structure of those documents and that co-employee relationship. None of that's ever been developed. That's fundamentally unfair to Young Living and highly prejudicial to us.
It's not fair.
It's not fair for them to change that evidentiary playing field after the jury's impaneled. Thank you, Your Honor.
Thank you.
So
Final
this is
word.
after the jury has left and everything.
Yeah. Yep. So thank you. Final word, Mr. Gaylord. We are tag teaming this because it's a whole moment. Repeating lawyers. Okay, first of all, he's dodging the issue, Your Honor. Oh, that's throwing the shade right back. Okay, I think this court's ruling was Rule 26 prohibits this. I think we demonstrated Rule 26 doesn't prohibit this. doesn't prohibit this. Second of all, we aren't walking back from the stipulation. The stipulation says defendant Harris entered a contract. It doesn't say it's the binding contract. We were very careful not to say it's a binding contract. Oh, right. We've always said, as Mr. Harrison will testify, he doesn't even recall seeing it or signing it, okay? But it appears to be a signature. He's not going to fight that issue. That doesn't mean it's the binding contract or we've agreed it's the binding contract. And certainly when he's provided with a copy of a subsequent agreement that he has, he's certainly capable and should be, or at least Mr. Young can testify, who's the president of ARMC, whether he has that, whether he knows there's a contract. More importantly, they've been on notice since May 14th of 2014 of Aromatic Resources Management. They're the ones who we asked. We might have asked Mr. Young about that relating to Mr. Hill, but that's because Mr. Hill, that's the agreement they wanted to use. The very identical agreement they now want to distance themselves from as it relates to Harrison and Shepard. And the question asked of him, I understand that Young Living, the plaintiff in this case, Young Living Essential Oils, uses another entity to sign its contract with its employees. Are you familiar with that? Objection to form and foundation. Go ahead. Mr. Young. Yes. If he wants to run back from that, I assume that's the question that's going to be asked. And he certainly is capable of answering that question at trial. They've had notice of that since that time. This isn't something that we've concocted out of thin air. And it is a legal theory. It's not a factual dispute. It's a legal theory. Show me where in the rules it says I have an obligation to disclose to these guys my legal theories. I can wait until the very end to tell them what those legal theories are. I can wait until I argue it to the jury what those legal theories are. What I shouldn't be denied is the ability to present the evidence that is there. Confusion. There's no confusion here. They entered into contracts. Those contracts exist. They have just as much of an opportunity to argue those contracts don't apply as I should be able to argue they do apply. And we're at that point. At the end of the day, Your Honor, I guess, the fact of the matter is we should at least have the right to present the documents or at least try to offer them into evidence and put them into the record. And what is troubling me is I'm being told now I can argue my case and what my legal theories are. There's nothing in the rules that requires me to disclose legal theories. My obligation is to disclose witnesses who may have information, knowledge, and documents. That's fair. In this case, there's a witness. These are two witnesses, Harrison and Shepard, who are defendants in this case. They had every opportunity to depose those defendants and did. They had all the documents they needed to depose those defendants. What I didn't have to do is turn around after I got the documents that they produced and say, oh, by the way, here's this new theory. I don't have to go through every one of their pages and come up with a new theory. It's part of the trial process. And I submit to Your Honor, under Rule 26, the court should reconsider, at least allow us the opportunity to present the evidence. And if the court wants to limit the instruction that I can't ask Mr. Harrison or Mr. Shepard about it, I'll accept that. What I don't think the court can do is deny me the right to impeach and examine the witnesses that they are going to put on to testify about what their responsibility is. That question that I just read to you is a perfect example. I should be able to ask that question of Mr. Young. Thank you. Me, the court, thank you. Mr. Toth.
Mr. Toth. Okay, so he's back. And that question that he posed to Mr. Hill had nothing to do with the argument that they're trying to make now. What's so telling about this, Your Honor, they filed a stipulation. They know they can't do what they're trying to do without walking back their stipulated jury instructions and the stipulated facts that are contained in those jury instructions. They can't do what they're trying to do. Now they want to backdoor. They've said, well, Judge, maybe what you meant was I can't talk to my clients about. They've said, well, Judge, maybe what you meant was I only can't talk to my clients about it, Ms. Shepard and Mr. Harrison, but I want to be able to go after their witnesses with them. It's the same thing. You're going to challenge our witnesses on...
Oh, wait, here we go. Yep, there we go. I'm good. I'm back.
You're going to challenge our witnesses on things that they have no basis to be challenged on. That's the whole point. Is you don't get to walk around the facts and the stipulations you've made and reinvent a new theory. Yes, you do have an obligation to disclose. You don't have an obligation to disclose a specific legal theory, but you do have an obligation to enter into appropriate jury instructions and stipulations and evidentiary stipulations before the court. That's why we go through that process, Your Honor. That's what Rule 26 requires us to do. Rule 26A 5 requires final pretrial disclosure, requires jury instructions, requires those stipulations. That's what the court asked us to do. That's what we engaged in with counsel. When they walked away from that, and when they want to walk back to a stipulation, that changes the playing field. That changes the game. That's not appropriate. We've never had a chance to address those issues with the court until Tuesday, when we suddenly find ourselves here on a motion we had, frankly, has no legal merit anyway. But here we are. Here we are. We're going to have wild speculation about whether these two entities are in the same. That's what they want to try to go into. That is going to confuse a jury, particularly in light of what the stipulated jury instructions are. That is fundamentally unfair to Young Living.
Oh, boo-hoo. Okay.
I'm say it's unfair to Young Living. Furthermore, to walk back, Your Honor, on a motion to reconsider, they haven't met the standard. Their attempt to walk their motion to reconsider doesn't even come close to meeting. We pointed that out in the objection. It doesn't come close to meeting what the Utah Supreme Court requires as proof to walk back the court's prior decision. Thank you.
All right. The court, thank you. We talked about Rule 26 last time, and I think it was the motion to reconsider, there was a citation to the advisory committee notes that talks about what's required for initial disclosures and the supplements that followed. The entire quotation from that portion of the advisory committee notes reads, "The summary of the witness's expected testimony should be just that, a summary. The rule does not require pre-filed testimony or detailed descriptions of everything a witness might say at trial. On the other hand, it requires more than the broad conclusory statements that often were made under those prior versions, the prior version of Rule 26A1. For example, the witness will testify about the events in question, or the witness will testify on causation. The intent of this requirement is to give the other side basic information concerning the subjects about which the witness is expected to testify at trial, so that the other side may determine the witness's relative importance in the case, whether the witness should be interviewed or deposed, and whether additional documents or information concerning the witness should be sought. This information is important because of the other discovery limits contained in the 2011 amendments, particularly the limits on depositions. So while I would concur that Rule 26 does not require disclosure of the theory per se, it does require disclosure about the direction that a witness is headed so that the other side is on notice of what issues are in play. I believe that at this point in trying to put in play which contract is the operative document, we are not keeping what is laid out in the rule as the rule in Rule 26. Moreover, it would require walking back a stipulation. The Supreme Court has recently issued an opinion regarding the standard for withdrawing admissions by opposing parties. I would cite it as Jordan Construction v. FNMA 2017, Utah 28. In paragraph 48, it indicates that a district court may permit withdrawal or amendment if two requirements are met. First, presentation of the merits of the action will be promoted. And second, withdrawal or amendments will not prejudice the party who requested the admission. Here, I would concur with the defendants that withdrawing the stipulation does at least arguably go to the merits of the case. Whether or not the non-solicit clause was offered or not is relevant and important, and I certainly respect and understand why defendants wish to go down that road. However, the second prong is impossible to meet at this point. Withdrawal of the stipulation would certainly prejudice Young Living at this stage. All the witnesses are called, everything is put in place with the facts as have been stipulated to. It is simply profoundly prejudicial as trial begins to change the issues and all of a sudden have this trial be about whether or not a different contract has been breached instead of the one that we have been talking about for 5 years. Oh my God. You know what? That is a shady move. You're gonna tell me that you're bringing something up like the week before your trial's going to court. You've been doing this for 5 years. Give me a
Right.
break.
Just kind of
Oh,
slides that in
yep.
there.
Yeah, that's sassy of the judge. I mean, we love it. We love a sassy judge. So I will not permit that theory, and I expect I'll be appealed on it, and maybe I'll be reversed. I'm willing to take that risk, I suppose. We'll go with the way it's been set. Mr. Gaylord, just for clarification, just so I'm clear with your ruling, I can't ask any witnesses about those agreements at all. That's your ruling? The court, well, I can't foreclose it. I suppose it might become relevant for impeachment purposes or something along those lines. Mr. Gaylord, okay. The court, I'm not going to say you can't bring up a line of questioning. We'll have to see how Mr. Young testifies. Mr. Gaylord, thank you, Your Honor. Court, all right. Is there anything else that we need to talk about? Mr. Smith,
Yes, Your Honor.
go ahead.
The court may recall that you've held back some rulings on motions.
Yes.
Young Living was kind enough to give a book to Your Honor and counsel that identified those that the court has.
I think I had it printed up. That there was a list, and I think I left it at my desk. Oh, okay.
Did you give them a book? I thought you gave them a book like this.
Mr. Toth, it's just a letter.
I'm sorry, it's just a letter. How do you
miss
a book with a letter?
I think it's kind of like Amber Heard's psychologist saying she's not reading the notes, and her notes are a ream of paper. I've just brought one note with me. This whole thing's my notes. I think it's that same idea.
Same idea.
God.
It's just a letter. Judge, you don't have what we have. I have a nice book. Would you like?
I'll try not to be too jealous. Oh, the judge is so sassy. Oh my gosh, we love it. We love it. Oh, this is amazing. Okay.
Would you like us to give you a book of the items that were identified in the letter?
There was a list. It was a table.
It was a May 8th letter to you from counsel.
That was probably an attachment to the letter. I thought I brought it out here, and it's probably sitting on my desk is where I left it.
The only thing I think we need to address at some point, sooner than later, is the issue that still deals with the limitation of damages within some type of a time period. And the reason I say that is after the summary judgment motion was denied, or the motion in Lamine, which you identified, Young Living has since stipulated to facts, the ones you just read. And in fact, they have since stipulated to is that a Young Living distributor was free to leave at any time. That was the issue upon which you denied the motion originally. You looked at the Aeon case, can't remember the other name of the case, Ocean Air, and a couple others from other jurisdictions. All of them were predicated on the fact that the client or customer was free to leave. We got a stipulation from them that they say the Young Living distributor is free to leave at any time, and that the final straw in that hat, because of that, the damages should be limited. Before you said that I need to limit, listen to some evidence to see that issue.
Yes, this was motion in limine. Was it 7? It was one of the motions in limine that we talked about.
I said lemonine or lemon. Sorry.
So when Emily D. Baker, like when she talks, a lot of people who are new to her chat thought she was saying motions in lemonade, like the drink. And so when they ask her questions, they're like, what's motion in lemonade? And so she's like, oh, it's lemonade. It sounds the same, but it's like, it's hilarious.
Interesting.
It's
good
hilarious.
to know. Lemonade with lavender essential oils.
Yes. Oh my. Yep. Motions. Yep.
Motion lemonade. Love it. All right, Mr. Gaylord, 5, Your Honor. Mr. Smith, our motion number 5, Mr. Straight. I haven't seen him pop up. That's funny. Mr. Straight, whenever you're finished, back to Mr. Smith. The court read that stipulation terribly prejudicial at this point in time to now say that they get to walk back after stipulation. We also have submitted the policies and procedures for Young Living, which we now have confirmed that these distributors can leave at any time. So that predicate which the court centered on and distinguished those two cases is now gone. And I suggest to the court that we need to look at it sooner than later. The other reason I think now is the time, at least the court may have to consider it, is we were handed their draft opening statement this afternoon according to our agreements. And in it, the last page, they have damages that are predicated upon exceeding the time limits. I thought the court wasn't going to allow them to show those to the jury until after you had heard some evidence. But if they want to show it in the opening tomorrow, we need to talk about this sooner than later. Now they want to prejudice the jury on that very issue the court was reserving on.
All right. Anything else? No, Your
Look at
Honor.
Mommy's comment.
Yeah. Mr. Gaylord, Mr. Straight, Gary Young, trying to cure homosexuality with oils, the irony. Oh, geez. Mombi, you're the best. Okay. And then Gaylord.
We concur with that, Your Honor.
Thank you. Oh, there's a Mr. Straight. I'm dying. I'm literally dying. Oh my gosh, this is hilarious.
Your Honor, the core issue in that motion in limine.
Yep.
Your Honor, the core issue in that motion in limine was the foreseeability of whether those damages would extend out by the people that entered into the contracts at that time. The stipulation he's talking about doesn't go to that issue at all. My understanding of the court's ruling was that you were going to reserve until we heard the evidence come in about what people's understanding and foreseeability the relevant people was, and then make a decision. And that's been the law of the case in this case for a long time. It did not go solely to the issue of whether distributors could leave or not. That's been part of Young Living's policies and procedures forever. I believe they argued that before. The core issue was foreseeability of those people that entered the contracts, and that evidence we haven't heard yet. Think that still needs to be reserved until the evidence comes in. Thank you, Your Honor.
But you would concur that showing the jury in opening statements anything about damages, the scope of damages at this point is premature.
Mr. Straight. I would respectfully disagree with that. I understand if that's what the court feels is appropriate until they hear more of the evidence. But we think it's important for them to understand what we're asking for up front. But we understand if the court disagrees with that. Our position is that it would be fine to show them that now, but then it's up to us to make sure we prove. Thank you.
All right. Thank you, said the court. Mombi and Dave are going to town in the chat. Your Honor, when the decision that I'm looking at is your order dated March 17th, 2016, and in it, the court goes back and looks at it starting at page 7, you'll find your language in there. But you indicated in identifying the Aon case, you said the customers were freely permitted to change companies. That was the reason why there was a limitation of damages. And then you say, thus, the trial court's decision appears to have been informed by the context of other evidence presented at trial. Since that decision, we went back and tried to get a stipulation on that very subject, and they have now conceded that their Young Living distributors were able to change companies at any time, and as a result of which, there is not a need to go and have a whole lot more evidence on that subject. We certainly can present it, but it's weird. The issue we're on all fours within Aon and Ocean Air. Both of those talked about the issue of free to move, and one was a 2-year limitation period where they violated it 8 months early. Ours is a 6-month limitation where I don't know what they're claiming exactly. They won't tell us the date that my client supposedly spoke to these people. Let's say February 28th, 45 days early. No, 32 days early. That is Aon. And at some point in time, the court needs to look at it. If the court still wants to reserve, I'm happy to reserve. And I would. But I would think that it's appropriate not to show the damages to the jury tomorrow on that sheet that come from this big number. And the court said, all right. And Mr. Gaylord.
Your Honor, I'm going to comment. I think that in the same order, you said there was a common thread in all of the cases that supports what Mr. Smith just indicated about the lockout period. And I think the issue is ripe now to make that decision because there's no new evidence. No more evidence. You need to make that decision. Hey, Carla. The court.
Sorry, it's me. I'm just like technical difficulties. Kat's like, you were serious about those. Yes, I was. I was totally serious about those. Thank you. I think it's appropriate to still reserve on that issue to see how the testimony comes in regarding the understanding of the parties with respect to foreseeability. I am loath to remove that issue from the jury at this point when I haven't yet heard how the testimony is going to come in, but I am. Well, actually, I don't know that there's any harm to anyone if Young Living shows it's just a demonstrative. Is that what it is, Mr. Straight?
That's right, Your Honor. Just shows the numbers.
The court, if they don't promote the numbers, it hurts them more than anyone. So if they want to show it, they can go ahead and show it. That's fine.
Mr. Straight. Thank you, Your Honor.
The court, anything else?
Mr. Smith. Your Honor, when you say, quote, it hurts them more than anyone, end quote, it prejudices the jury. But if that's your ruling, I don't plan on fighting every time you rule. It just seems that there is prejudicial to my clients to put, I think it's 14 million across the board damage number up there that may not make it past $35 at the end of the day. That's the issue. It's enormous, the difference in dollar amounts.
It is. I understand the concern. However, it's long been my belief as an attorney, if you make promises to a jury in opening statements and that doesn't come through, you're the one with egg on your face. I don't think the jury will hold it against anyone else.
Thank you.
All right, said the court. And Mr. Toth, I was going to say, I think there's some additional housekeeping issues, Your Honor. Good God, why do they keep talking? I'm just kidding. Okay, that might speed things up at trial a little. I don't know whether it's best just to raise them in open court, or I can talk to defendant's counsel on some of these issues. There are a number of rulings the court has already made. Let me give you an example. In defendant's renewed motion in Limine 3 and 6, the court primarily granted the defendants the relief they sought in those. The court excluded certain exhibits and then went through an analysis as to why they were relative and probative. Those exhibits, for example, Your Honor, have not been. The defendants still have an outstanding objection to those on relevance grounds. Since the court has already ruled on those, we'd really like to take the time now and not in front of the jury trying to go through relevancy objections to clean up the exhibit list and get through have these exhibits stipulated too so that the parties can move quickly through evidence and effectively through evidence in front of the jury, in front of the court, and minimize our waste of time. We also think there are issues about, for example, Mr. Harrison's phone records. The court actually addressed that issue in that motion in Limine number 6 and found that those were admissible. The defendants have relied on those phone records to seek relief from the court, and the court has granted relief based on those phone records for the defendants. Those are, Utah case law is quite clear. You can't secretly fund part of an exhibit and claim that some of it can't be admitted. It's an admissible exhibit. Again, that's something else. The phone records should be in. All of the exhibits the court has dealt with in those motions, we really would like to either have the court do it or work with defense counsel to do it. We'd get some of this record cleaned up so we're not messing around with trying to get different types of records into evidence when we could deal with it right now. So there are also exhibits, Your Honor, that both sides have designated. If we both designated them as an exhibit and the other side still has an objection, that doesn't make any sense. Doesn't make any sense. If we both designated an exhibit, we ought to be able to use it. So let's clean up our exhibit list in front of the court so that we can get this. We can anyway. What is this guy saying? I'm trying to make the process more efficient, Your Honor. Why don't you say it clearer? What the hell is he saying? Okay. We thought as a housekeeping matter, jury has gone home. It's something we can probably get hopefully cleaned up in the next half hour, 45 minutes. Maybe the court can take a brief recess. We can sit down with counsel and walk through some of this. Whatever Your Honor thinks is the best way to proceed. The court, I did go through, it's probably another thing I left on my desk, the deposition designations. There have been the form that was given to me to make my ruling. I've done that, which can speed things up with respect to the depositions. A similar document has been presented on all of the evidentiary objections. I have some tentative notes on those. A lot of that, I think, depends on how the evidence comes in. I don't want to make premature rulings on things until I can see how the relevant issue plays out during the course of the trial. But if there's some stipulations that you think you can still hammer out, that's fine. I can give you the deposition rulings that I've made, and that can help speed things along. Mr. Toth.
That would probably help, Your Honor. I'm not asking for the court to. I understand your concern about some of them. Hi, Jess. There are relevancy.
Pat, love you.
Reese's peanut butter cup sounds amazing right now, by the way. All right. There are relevancy objections on both sides, and they're either not jointly stipulated, they're either not jointly designated, or they're not subject to an existing ruling of the court. I understand that. I'm just saying there are certain ones, particularly the exhibits contained in the motion in limine number 6, Your Honor. I can read it that Your Honor went through, frankly, when you pointed out granting, frankly, the defendant's request for relief in that motion, the court said the expectations would all be these emails offered as exhibits. And then you listed the exhibits and you point out they're outside of the 404-B analysis. And in fact, they corroborate the defendant's we're planning to build doTERRA by soliciting from the ranks of young living. Let me read that again. That's huge.
No, you're good. That's just T. That's major T. Go ahead.
Yeah, so read it again. And you point out they're outside of the 404-B analysis. And in fact, they corroborate the defendants were planning to build doTERRA by soliciting from the ranks of young living. And you specifically find, quote, this plan is prohibitive as to young living central theory, that the 13 solicitees were contracted for recruitment purposes, end quote. In other words, the court went through and made a relevant analysis for us. We didn't think we should have to go now. We don't think we should have to go. Oh my goodness. We don't think we should have to now go through. There's no reasons the defendant should be willing to stipulate to that. The question has been resolved by the court. And so can we take those off the list, check admitted, and move on? I know the defendants intend to reference them in their opening. We're using them in our opening. It's another issue trying to speed the trial along.
The court, I recall specifically those exhibits as I went through the objections. I agreed with you on all those points, and the notes that I made were that those should come in, including the phone records.
Mr. Toth. Okay, thank you, Your Honor. Is there a way sorry, I've got 3 lawyers talking to me, Your Honor, I apologize.
The court, I know how you feel. This judge is hilarious. Oh my God.
Anyway, is there a way for us could the court...
The court, do you want to take a few moments and talk? I'll go back and get the deposition notes I made. I wonder if those others are in one of the binders.
That would be super helpful, Your Honor.
Mr. Gaylord, before you, I'm sorry, I don't mean to interrupt. Yes, you did. You're a lawyer. What the hell? Okay, sorry. The court. No, you're fine. Mr. Gaylord, I need to clarify. Are you saying you've made rulings, or you just have got notes on those rulings and those issues are still open? Like phone records. I have strong objections to the phone records coming in at all. And we've made our objections, but it's not clear how they're coming in. And until they do come in, if the court wants, I can address that. Why we think they're objectionable. The court, as I recall, some of the objections were foundational. Mr. Gaylord, some were authentication. The court, it's all subject to that. As far as relevancy and those sorts of things, yes, I think they're clearly relevant. It would any exhibit is subject to laying proper foundation, so forth, unless it's been stipulated to, obviously. Mr. Gaylord. Okay, Mr. Toth coming up. Okay, Mr. Gaylord, Mr. Toth is trying to suggest we've used them in our case. They didn't object to our using them. When it goes to this trial, we were going to object to the use of those phone records because they've never authenticated them. That's a foundational issue. As long as we're preserved on that, that's our concern. On the other ones, I guess my clarification is there are other considerations that go into the admissibility. Until, I think what the court's point was, until we see how it comes in, they aren't going to hamstring us and not be able to tell us what our objections are. Until they come in, we shouldn't. We should have the right to raise any objections that we have. Mr. Toth.
Mr. Toth, and that's exactly why I think it's worth trying to address some of these issues now. Mr. Harrison is going to be confronted with his phone records, and we're going to ask him, are those your phone records? He didn't dispute it in his deposition. They've used those phone records to seek affirmative relief for Mr. Harrison, and they've obtained affirmative relief without challenging the authenticity of those records. They've used them themselves. To suggest now that they have the very same phone records that they used to obtain affirmative relief for Mr. Harrison are now not admissible for Young Living's purposes is contrary to the Utah case law. And to have to waste a jury's time in a 20 or 30 minute, maybe it won't last that long, Your Honor, we'll try to put a kibosh on it. But an evidentiary argument, when we try to bring it in and excuse a jury and whatever else we're going to try to have to do, it makes sense to me, Your Honor. Let's clear the deck and get some of this resolved now. That is my suggestion. Anyway, obviously, it's a court's decision.
Mr. Smith, Your Honor, when counsel says that those were presented to Mr. Harrison's deposition, he didn't object. That was the first day I appeared in this case, and on that day, I have a pretty good recollection of what happened. Mr. Toth presented that he now claims are the phone records, only to find out that they had been sent to counsel the night before on Friday night at 5, and those phone records had been in their possession for 3 months. This court sanctioned them for that conduct. The court, I recall that. Mr. Smith, for him to say that Mr. Harrison didn't object to the phone records in his deposition that were handed there the first day, I don't think that's really fair to anyone. They were sanctioned for that conduct. I think there's a valid objection for foundation, and that's the issue that's been raised by Mr. Harrison's counsel.
Mr. Toth, so to address that, Your Honor, Mr. Harrison didn't say that they weren't his phone records. In fact, he acknowledged they were. That notwithstanding, more importantly, 2 years later, that the defendants filed a motion regarding, you remember the long list of solicitees? They challenged whether there was evidence. Mr. Hawkins submitted an affidavit in which he claims he literally says, I carefully scrutinized Justin Harris's phone records. There are no calls here. These calls only occurred after this person joined, end quote. They utilized those phone records for their benefit. And the court ruled using those phone records in part to give affirmative relief to Mr. Harrison on certain solicitees, alleged solicitees. So they have used those phone records to obtain relief. The very same phone records they now want to say they shouldn't come in. More importantly, we have provided the court every one of those phone records. They have been provided declarations from the custodians of proper authentication for all of those phone records. They have all those materials, so they've used them. They have authenticity declarations for the custodians, and there's no one who's actually challenged. If you want to look, if you like to talk about authenticity, you look at something like 9014 or 9014. They're phone records from the phone company. There's all the hallmarks that they are exactly what they purport to be. They have not offered a shred of evidence that they are not phone records from Verizon. So this is why I'm hoping we don't have to spend jury trial time going over these issues with what seem to be, to me, to be very basic questions about admissibility, about very basic evidence.
Mr. Gaylord, Your Honor, I'm happy to bring this up. I didn't think this issue was coming up. I have a binder. I have evidence that the authentication of Mr. Harrison's phone records won't stand the test of time. The document Bates numbers, if y'all don't know, are how you track evidence in their systems. So if you Bates number something, it's a little code that's either printed digitally on it. Back in the day, you used to do stickers with like a barcode, and it would, when you scan it into the system, it would scan it into the computer so you can search. Anyways,
that's a 4015, yeah. That number.
Yep.
Whatever it was, yeah.
The document Bates numbers are different than the document Bates numbers in the declaration, which that might mean that it's not authentic, or it might mean someone who produced this, like who was copying this for trial, messed up. It might not actually be an actual authentication. Just, I worked in that industry with my dad. That's what we used to do, is digital document support for law firms. So the document Bates numbers are different than the document Bates numbers in the declaration. The date that the letter of declaration was given is 5 months after the documents were produced. There's no way of tying in those phone records to the declaration. So the question is, are they authentic? Before they can present that document to Mr. Harrison to review and be asked questions about it, they have to authenticate it under Rule 902-11. They haven't done it. and I will demonstrate to the court tomorrow. I'm happy to bring to the court all the evidence to demonstrate they have not properly authenticated these documents with these declarations they produced. We raised those objections in our argument. We pointed out 902. They sent us, we asked for copies. We got copies of those declarations. What those declarations show is that the date that the document was produced is in July or June of 2013. Mr. Harrison's deposition is taken in August of 2013. We get them a week later, and then what happens is in May, like in 5 months later, there's this letter. No tie to the very documents that were produced. The Bates stamp is 11,500 something. The documents that were produced are 5,964. There's no tying in those two documents together. And for Mr. Toth to come up here and say we've got authentication, it's easy. We always use them. They're the ones that represented what they are. If they want to object because they aren't authentic or they aren't what they purport to be, it doesn't deny us the right when we come to trial that they haven't properly authenticated them. I'm happy to bring that to you tomorrow. I want you to know the timing of it. That's true, quite honestly, Your Honor. Of every one of the phone records that they've produced, they controlled it. Unless they can authenticate, they can't come in. The court, let me just take a brief recess so I can gather a few of those documents. I think we'll resolve a handful of issues. I hope. I'd hate for us to go through this for every exhibit in every one of these binders. Ooh, she's pissed. Oh my gosh. Let me go get those and give you a minute. It's 4:30, so we probably don't want to go too much longer tonight. I have a piano recital. We'll take a recess. Recess taken at 4:24, resuming at 4:39. The court, thank you. You may be seated. You can make that part of the record, and here's the copies. You may have to share a little. I think I did 8. I probably didn't count very well. Bailiff?
Yes. Want to give them one more? I only think I gave them 3.
The court, all right. Have we worked out any agreements?
Yes, we agree. We have worked out. Well, no.
Not my bad.
We agree that we need to look over the night and come back early before court and see if we can't resolve.
That works. Today's not a very good day to stay late for me.
They're going to email me something to look at overnight.
The court, I'll keep these on the bench so we can talk about it tomorrow then. Was there anything else that we needed for this afternoon or evening?
Your Honor, there's just maybe one more thing.
Oh, God. The court, sure.
Of course, we are wondering what the court's view was in light of tomorrow's opening. The court has not issued a ruling on what the definition of solicitation will be, and we're wondering if the court can give us direction. We both have submitted proposed, but we would argue that it has to be, and there's 2 issues. That doesn't make any sense. Okay. 1, what the definition of solicitation is. 2, when does a young living distributor become acquainted? And it has to be, I think you said 4 or 5 business relationship with a distributor before that person would be in a class they would be prohibited from soliciting. We're hoping to get direction from the court on that. There could be things we say in the opening that are important to us. We're hoping to know whether the court is going to basically say which jury instruction is going to rule on those 2 issues. I can give you the jury instructions if it would be helpful.
The court, I know I've looked at those and my preference, well, we've gone through in some detail the definition of solicitation. The others we've not. So my preference would be to use the common meaning.
Okay. Mr. Gaylord. Well, I think on solicitation, we both have fairly typical, solicit has the following meaning: to mean, quote, to make petition, to entreat, to approach with a request or a plea, or to urge as one's cause strongly, end quote. It's not, quote, call upon or, end quote, or, quote, call them, end quote. You've got to actually urge them to act and not to just call on somebody. That's not necessarily solicitation. So that would be the first issue. And then the other issue in terms of, I realize what you're saying is it's kind of common, but the way that the provision is written, the section is written as it relates to become acquainted. It is, you call, give me the contract. I want to get this right.
Mr. Hawkins, I apologize, Your Honor. I think what Mr. Gaylord is trying to paraphrase in the contract is the provision that says, call upon, service, solicit, or become acquainted with as a result of the employment with Young Living. And the position that we already advanced, and we've already had one opportunity to argue, was whether or not what that really means is they had to have forfeited or established a business relationship with these people why they were at Young Living. So it would not preclude somebody who had a pre-existing relationship before Young Living from soliciting that person. So that's the position. I believe that's the issue that Mr. Gaylord was identifying. And we call it sort of the class of distributors that the defendants were prohibited from soliciting. So is the court prepared to give us guidance on that? The court. Well, I'm certainly happy to hear from Young Living before I say anything.
Mr. Hawkins, do you want me to address the other issue? The other issue is with the respect to prohibition, the solicitation clause. It includes 4 different words: call upon, divert, take away, or solicit. And I believe that's all of them. And we advanced the position last time that we briefed this for Your Honor as well, that frankly, Your Honor has already defined all of those terms as solicitation. We briefed this issue way back when Ms. Shefford filed her motion for summary judgment on solicitation and made arguments then. Your Honor produced only one definition what that prohibition means. We're not left with 4 independent meanings for which a defendant could breach that particular provision, but rather just one, which is to say solicitation. Do you have any questions about that?
The court, no, I'm trying to get to a piano recital. I'm just kidding. No, thank you. Oh, okay.
Mr. Smith.
Okay.
I think the issue, while it's a much more minor issue for my clients, Your Honor, it deals with your ruling on September 23rd on page 19. In that ruling, you kind of had 2 definitions for solicitation. One is you cited the Merriam-Webster definition, which said, quote, petition to entreat, to approach with a request, or to plea, or to urge strongly, end quote. And then just down below that, in the next paragraph down, you said, quote, in other words, it's...
Scroll, DC, scroll.
You said, in other words, it's petition, plea, or request, end quote. So the question really is it, quote, petition, plea, or request, end quote, which you kind of summarized, or is it the Webster dictionary, which is, quote, petition, plea, or urge strongly, end quote. I think urge strongly is different than request, but that's the definition. That's the dictionary definition. As far as I'm concerned, my clients never met with the people before the lockout periods or talked to them. So I don't think I'm going to be under petition, plea, entreat, approach, request, or whatever. But I think it's important to the jury to understand what the term is going to be. I think you already said, maybe I'm wrong, but you said it's not a legal term. It's not defined in the contract, and the jury has to decide what that means. But guidance would be helpful.
Okay, the court, thank you. I'll be Mr. Burger. We'll say Burger. It's probably not Burger, but we're just going to call him Burger. Okay, Mr. Burger, Your Honor, on that point, I'm not sure that Young Living is fully prepared to respond. But my recollection is that there was only one term that was at issue before Your Honor, and that is the meaning of the term solicit in the contract. There was no suggestion, attempt to prove or lump together any of the other prohibitions that applied to Harrison and Shepard, and there were additional words in the contract. And those additional words have to have some additional meaning, one would think. So when it talks about diverting or taking away business in addition to solicitation, Your Honor defined, and we fought over a lot of briefing over what solicit means. Your Honor went to the dictionary and, as a lexicographer's issuing opinion talked about what solicit means, Your Honor defined that term. Your Honor didn't identify or purport to identify what the other terms meant. So that ruling of yours as to what the term solicit means doesn't read other terms out of the contracts. We can perhaps respond more fully tomorrow after we've had a chance to look at the order you entered. That's my recollection. The court, thank you.
And salad. Add that to dinner too. Yeah. Burgers, lemonade.
Yes, seriously.
Side salad. Mr. Hawkins, Your Honor, if I might address it from here in the interest of time. From day one, Young Living has litigated this case using only one term, and that term is solicit. We've all dealt with that, grappled with it. Your Honor defined that particular term, and that's the operative definition that we've used for the whole trial, the whole case. And I think it would be inappropriate for them to shift that theory, which was not disclosed in Rule 26 or anywhere at this point. That's just all I have to add. Thanks.
I need to go to a darn piano recital. Okay, I'm just kidding. The court. Well, why don't we sleep on that one? I appreciate everyone's position, but I think that may have caught some off guard a little bit. And I don't want to change the landscape or anything without giving everyone a chance to think about that. Tell anyone how they have to argue their opening statements until you've had a chance to think about that. We'll discuss that in the morning. Anything else for tonight? Oh my God, Mr. Smith. Oh my
Last issue, Your Honor. I know notice went out that said they have Thursdays off. Are you going to tell them or post the time?
The court, yes, we'll discuss the schedule some more tomorrow. It did say it in the letter. You can hear it. She wants to go to her kid's piano recital. God dang it.
I think it did. That's why I was surprised. You might want to point that out to them.
Bailiff, it also says that on the door of their jury room.
Thank you, Your Honor.
We'll make sure it's clear as bell. All right. The proceedings concluded at 4:51 p.m. Holy. So this is the reporter certificate. So we're not going to read that. Kat's literally never going to live stream with me again. She's going to be like, what the hell was that cluster? That's the first transcript. Kat, what do you think?
I had a blast. I think it would be fun if I had different things, different costumes to put on.
If you got to see this live stream, you're lucky. I'm going to take it down. I'm going to edit it. We're going to edit out the technical difficulties. Wow. I'm going to send the video to Kat. I'm going to re-upload it. And Kat and I are going to try to schedule next time to read the next part. And I won't screw up the live stream.
Figure it out.
It has been a blast. This is the first time Kat and I have ever talked like in real life to each other over the stream. And Mombi was the one that connected us. It's been great. Everyone in the live chat and the replay crew, give a big shout out to Mombi for sending us these transcripts. She is the reason that we had something interesting and slightly dry to read, but we definitely appreciate the judge, how sassy she is. And if you want a sneak peek, go to Mombi's Instagram and click on her highlight. She has a Young Living highlight, and you're going to see a little sneak peek of some of the, I don't even know what to say. The things you never expected to read in a deposition, you're going to read in that. Doing surgery without a license, something inappropriate with Bic pens. I'm not going to give it away. Your imagination is partly gone there, but you can know exactly where it's supposed to go when you go see those story highlights. It's wild.
You'll never use a Bic pen.
You'll never use a Bic pen again.
Yeah.
You never will. These trial readings, we're going to have a completely separate cover image that's going to be easy to see. So if you just are like, I got to have the legal readings, you're going to be able to go to them straight on my page. I'm going to make the cover available to Kat for her page. I'm going to connect her channel to my StreamYard. So next time we stream, she'll be live too. Thank you for bearing with us with the technical difficulties. I appreciate it. Y'all are always so gracious and kind. And I think you realize that I'm just like Elaine. I'm doing my best, Your Honor. We will see you on the next live stream. Kat, it was a pleasure having you. Everyone loves you in the live chat, and your reading voice is impeccable. We loved it. Yeah, I'm going to roll the outro music, and we'll see everybody next time.